Good afternoon and welcome to Fiduciary September, the largest annual conversation of investment advisors, financial planners, and experts on the importance of fiduciary advice. This panel, Reg BI enforcement and guidance, will drill down on the meaning of Reg BI after 2 years. And we hope to be able to not only identify the shortfalls, but to be able to offer solutions to go forward and to improve the situation that we see. On this panel, we have Ron Rhoades from Western Kentucky University. We have August Iorio from Iorio and Altamirano, a law firm in the New York City area. And we have Ben Edwards, professor, Las Vegas Boyd School of Law, the great state of Nevada. And then we have Peter Mafteiu, a compliance consultant, also from New York State. Peter, are you here? I don't see you on the board, but maybe on one of the callers. Javier, are we still being under being recorded? Correct?
Yes, we're still being recorded.
Okay, all right. So on this panel, we will have each of our panelists speak for about 5 minutes on different aspects of Reg BI, and then open the discussion to questions from our friends from the Fourth Estate and others if time allows. So with that short introduction, Ron, are you ready to go?
All set.
Okay, you're on.
Well, thanks, Knut. Of course, everyone, please be aware of my remarks are mine alone and not necessarily representative of any institution, firm, organization, or cult that I have ever been a member of or been kicked out of. First, I'd like to share a little history on Reg BI. Reg BI is basically the result of a huge mistake by FINRA that it made back in 2011. It stated in Regulatory Notice 11-02 that brokers had an obligation to act in their customers' best interest. FINRA based this conclusion on cases that appeared in which brokers were held to a fiduciary standard under state common law. There was never a blanket imposition of a best interest standard on all brokers by the courts. The duty to act in a customer's best interest was only imposed in those cases when the broker crossed the line and entered into a relationship of trust with the customer. In essence, became a fiduciary. So first off, just an observation, if I was at the SEC and looking back, if you did the research, go back and look at those cases, I'd reach that conclusion. I'd be really mad at FINRA, just to start off with. We have to kind of put this in perspective. We must understand that for millennia now, there have been two major types of commercial relationships from the law. One is the arm's length relationship, in which basically you have a seller and you have a buyer. And then you have this other relationship that's not imposed very often. It's reserved for situations in which there's this relationship of trust and confidence, and that, of course, is the fiduciary and trustor fiduciary client relationship. Now, in that fiduciary client relationship, the fiduciary has several duties, including this duty of loyalty. And for centuries, courts have stated that this duty of loyalty requires fiduciaries to act in the best interest of the client. In fact, the duty of loyalty is basically equated with this duty to act in best interest in over 9,000 court decisions in the US alone, not to mention all the court decisions in England, Australia, and other civil law jurisdictions, common law jurisdictions rather. Yet with Reg BI, which was proposed by the broker-dealer community, the term best interest has essentially been redefined. best interest under Reg BI is no longer the strict fiduciary duty of loyalty. It has this second definition, which unfortunately remains quite vague. And unlike the fiduciary standard, which has these other obligations, there's no obligation under Reg BI to ensure that only reasonable compensation is received. That's a core fiduciary duty. There's this duty of care under Reg BI, but that's yet to be defined, how strictly it's going to be applied. So Reg BI is not a fiduciary standard, it's something else. But 2 years after the regulation's effective date, we really don't know what it requires. Reg BI, in my view, has essentially turned the law upside down. A broker is a distributor of investment products. A broker is a seller. Courts have opined on many occasions that you can't wear two hats. You can't act in the customer's best interest as a fiduciary and also sell to that very same customer a fiduciary. You're just trying to represent two sides at once. As Skip Twice stated on the prior panel, and I agree with him, there's absolutely a role for brokers, product sellers in our society. They should be able to sell products. That's perfectly fine. But I'm not in favor of brokers pretending to act in the best interest of their customers, pretending to be trusted advisors when that's not the case. So in my view, Reg BI is fundamentally flawed. It rests upon a premise, a conclusion by FINRA that was incorrect. It's a regulation that confuses investors. It leads consumers to believe that brokers are loyal to the investor's interest when in fact that's not the case. I fear that when we look back years from now, decades from now, we're going to state with astonishment, what was everybody thinking in proposing and adopting Reg BI and redefining this whole concept of best interest that came down to us for centuries? It's kind of sad right now that those in the consumer press really need to warn consumers, just because someone says they are required by law to act in your best interest, that doesn't necessarily mean that that's actually happening, as you, a consumer, would understand that term. Now, despite all this, and as Brian Hamburger alluded on the prior panel, the fiduciary business model was winning in the marketplace. More and more financial advisors are moving away from the broker-dealer model to the investment advisor model. That, and of course the DOL's rulemakings applying its stricter standard, have been very positive developments. Kind of in conclusion, I believe that Reg BI should be repealed. I think it ought to be replaced with a new regulation. I would call it Regulation Conflict of Interest, or Reg CI, that outlaws many of the conflicts of interest that shouldn't exist, such as sales contest, payment for shelf space, payment for order flow, 12B1 fees, and other forms of revenue sharing. Commission-based compensation should still be permitted, but all of these other ways that brokers siphon off portions of other people's money should be disallowed. But of course, others on our panel have different views. And with that, I turn the microphone back over to that very subtle Norwegian, Knut.
Thank you, Rod. Next in line, August.
Yes, hello. My name is August Iorio. I'm a managing partner at the law firm Iorio Altamirano LLP. It's a securities arbitration law firm based in New York City. We represent investors nationwide in helping them recover investment losses as a result of broker misconduct or negligence. Reg BI is important to us because the obligations that it imposes on brokers and firms also define the standard of care that it's owed to customers when adjudicating individual arbitration claims. Even though based on our experience, almost all retail investors believe that their brokers have a fiduciary obligation, that has not been the standard, as we all know. Since Reg BI went into effect in June 2020, we've been monitoring whether it would increase the degree of prudence required by brokers or broker dealers when making investment recommendations, from the suitability standard to something more. I just came from a panel discussion on this exact topic that included industry professionals, experts, and consumer side advocates. And I can tell you that The majority of the people believe that it's akin to a suitability standard, but they do believe it provides a little bit more. What that is kind of to be determined, and something that everyone's trying to figure out. One hint of that, we can take a look at what happened earlier this year, in that the SEC filed its first enforcement action against Western International Securities in June 2022. It's the first substantive Reg BI enforcement action against broker-dealer and 5 brokers, and that was brought in connection with recommending and selling GWGL bonds to investors. Notably, the SEC's enforcement action against Western International only alleges violations of the care and obligations and the care and compliance obligations of Reg BI. The SEC lawsuit against Western International accuses the firm and its brokers for violating the care obligations in 2 ways. First, by failing to exercise reasonable diligence, care, and skill to understand the risks, rewards, and costs associated with L bonds. And second, by failing to exercise reasonable diligence, care, and skill to have a reasonable basis to believe that the recommendation was in the best interest of several retail customers. Now, this care obligation of Reg BI and the way it seems to be being enforced is very similar to how a suitability claim would have been litigated before Reg BI. There are two subtle differences, or maybe not that so subtle, but we'll have to see more how it plays out. But one is that the care obligation appears, that the SEC appears to be taking into consideration the cost of a product in relation to other reasonably available alternatives. And that's the second part of the care obligation, is has the broker provided the customer with other reasonably available alternatives. Now, those 2 factors, I would say, maybe weren't as prevalent in the suitability analysis, but those are 2 things that people within the industry, both on the defense side and on the plaintiff side, have been looking at as to whether that elevates or raises the bar for the care obligation as opposed to the old suitability rule. Second, the second allegation that the SEC brought was that that the lawsuit alleged was that Western International violated the Reg BI's compliance obligation, which requires brokers and dealers to establish, maintain, and enforce written policies and procedures reasonably designed to achieve compliance with the care obligation or the other obligations. In this case, because the SEC had only brought allegations with respect to the care obligations or violations with respect to the care obligations, the compliance violations all relate or arise out of the care obligations. The filing, of the lawsuit is significant in that it confirms what we've suspected. Our law firm has been tracking the GWGL bonds for about a year and has done a significant investigations related to it. We had believed for some time that many brokerage firms did not have their best interest in their customers when they recommended these GWGL bonds. These L bonds, just for a little bit of a background, they're financial products that were created and issued by GWG, a company that used to be in the business of selling life, or in the life settlements business. They sold over $2 billion worth of these L bonds through a network of broker dealers across the country. These are risky, illiquid, and very speculative securities. In addition, and quite significantly with respect to what's going on in this Western International case and also individual arbitration actions, is that GWG materially changed its business model beginning in 2018. That material change, by 2019, they were a completely different company, I would argue, than they were in 2018, yet brokers continued to sell the product as if it was from the old business model, and many brokers told customers that they were in the life settlements business. And this is based on our conversations with over 100 GWGL bond investors across the country. And we believe because of that, there's been widespread failures by brokers and firms to provide a fair and balanced point of sale disclosures regarding fees, costs, and risks to retail investors. And when recommending these products, rarely did the firms provide any reasonable available alternatives. We believe that brokers and firms are incentivized to sell these securities because of the high commissions that they received. When they sell these things are called L bonds. They're described by some people as corporate bonds or promissory notes. They're treated by firms and other brokers sometimes as alternative investments. They are such because they receive higher commissions for it. A bond, you might receive 30 basis points. This GWGL bond, the firm was receiving between 3.5 and 5.5% commission on the face value of the bond, which was 85 to 90+% went to the brokers. And that's significant because the SEC's complaint did not allege any violations with respect based on the disclosure obligations or the conflict of interest obligations. The disclosure obligations includes a disclosure of the material conflict of interest. We're encouraged that the SEC has taken this action. We would like the SEC to have gone further in addressing the violations of Reg BI's conflict of interest, particularly the inherent conflict of interest related to brokers maximizing their own compensation at the expense of customers. We believe that brokers and firms have incentives to sell L bonds, again, because of their commissions. And again, because of the type of products that these brokers were receiving a higher commission to sell these alternative products as opposed to traditional brokerage business products. This raises conflicts, placing the broker's interest obviously in direct competition with investors. We've seen many cases where the brokers justify the recommendation because it produces income for the investor with no appreciation for the ultimate risk or liquidity of the product. After filing numerous FINRA arbitration claims and speaking with and interviewing over 100 investors, that's precisely what was going on here. In fact, our law firm is representing a permanently disabled woman whom Western International recommended that she invest a significant portion of her medical liability settlement into GWGL bonds. We expect to file a FINRA arbitration claim for her within the next week to help her recover her irreplaceable $400,000 capital investment. Because of the widespread sale of these GWGL bonds across the country by brokerage firms, we believe that the SEC has an opportunity in future enforcement actions to make it clear that these sorts of recommendations are inconsistent with Reg BI, and we hope that there will be much greater scrutiny with respect to the recommendations of the high commission and risky products, particularly when they're sold to retirees. We hope that the future enforcement actions will start to address some of these issues with respect to the conflicts of interest obligation and the disclosure obligation related to conflicts as well. Thank you so much. Happy to answer any questions when we're done.
Thank you, August. Ben, you're up.
Oh, well, so let me begin by saying thank you to the Institute and for our other panelists and audience members for being here to talk about this. These are incredibly important issues, and I'm very glad to be able to participate and provide my view. Like Ron, my views are my views alone. They are not the views of the law school or the University of Nevada, Las Vegas. But I of course think I'm right. So turning to this and thinking about the situation that we find ourselves in now with regulation best interest. If you're trying to evaluate the scope and the boundary areas for Reg BI, it's very hard to do. It's very difficult to determine exactly where a lot of these boundary lines are. Regulation best interest calls for firms to mitigate conflicts, disclose conflicts, and do a number of things. But it leaves a lot up to the firms themselves to decide exactly how far they're going to go. And so if you have brokerage firms who are interested in maximizing their short-term profits, there is a large amount of room to continue to exploit conflicts of interest. So what we see with the SEC right now is it has the difficult task of trying to raise overall sales practice standards and the quality of financial advice in our country. Yet the tool it has at hand to do this is regulation best interest. and it is a very difficult thing for the SEC to do. So the danger it faces is that if it tries too aggressively to strengthen regulation best interests through additional guidance or enforcement actions, the more those actions move forward or look the standard, they increase the possibility that there's going to be some real litigation risk to being able to accomplish those goals. So broker dealers are going to challenge in court, they're going to fight it, and the arguments are going to be that if the SEC is trying to require more, it should have required more when it made the rule. Or it may be that they'll argue that Congress is the only one who could require more in this space under the authority the SEC has. So what we face right now, and the situation with the first enforcement action is a really good example of it. It's somewhat more difficult for the SEC to enforce on the conflict portion of it. But when it comes to the duty of care, there's some bright line rules, and the GWGL bonds are an excellent example of this. This is a company that fundamentally changed, its business process. The nature of its business changed dramatically. All of this was disclosed, in its filings. It did not hide this, as a company. But for ordinary investors, they don't go out and read these disclosures. They don't go look at all the bond offerings they could possibly participate in and then select the optimal one. What they tend to do is find a financial advisor, oftentimes a stockbroker, and then trust them to help them find the right investment. Now, regulation best interest is supposed to give some assurance that people will end up with investments that are roughly right for their situation. But what we see here is that that's simply not working in many instances, and part of the reason for that is that brokerage firms are by and large operating simply to sell product and make profits, not to pair people with the right investments for their situation. They recognize that they can face some liability if they do too poor of a job along that metric, but the pressure is always towards sales. So if you're thinking about the GWG bond action and the enforcement action there's a lot to think about from an investor protection angle. I'd like to highlight a different angle here, which is the risk to our economy. So the underlying issuer here is a company that likely would have gone out of business much sooner. It's in bankruptcy now, I believe. Probably would have entered bankruptcy sooner if it had not been able to continue to raise capital. We now know that much of that capital was raised by very misleading representations about the nature of the investment. The company was described as doing things it simply no longer did. And the reason why the bonds were so aggressively sold, despite the people selling them paying so little attention to what they actually were, is because of the commissions. And without restraining this conflict of interest and this incentive structure, the SEC is always going to face a problem with capital formation and capital flows getting distorted simply because of these kinds of conflicts of interest. So ultimately, we need to do a lot more as a society and through the SEC and Congress to do whatever we can to improve the standard for advice, not just to protect investors, but also to make it a fair marketplace for capital formation, so that you're not able to raise more money than another company simply because you're willing to grease the middlemen more.
Thank you, Ben. Peter, are you on one of the phone lines or not? All right. Peter does not seem to be here, so I will go ahead and offer my brief comments, and I do so with great humility, following these securities attorneys, a PhD, and a professor of financial planning. But I want to focus on what I see as two areas that have been underreported in a sense, but are extremely important in terms of understanding where we are today. And the first one I want to say, well, is underreported in terms of its implications. that has to do with not defining best interest. And so it hasn't been, it's not reported in the sense that consumer advocates have pointed this out since the get-go, since the release of Reg BI. But what I don't think has been reported very much is, so what? So what that the SEC decides not to define best interest? What does that mean? Why should anybody care? And this is where I think there's an untold story that that really is relevant. That has to do with where we are today. Not only is it not defined, but the SEC boasts in its communications that and is proud of the fact that it hasn't defined best interest. They've suggested that not defining best interest is in the best interest of consumers. So there you go. So what does that mean? And I think you don't have to be a professor or a PhD, no disrespect to anybody here, to think that, well, maybe that's going to cause even more confusion in the marketplace. And it's not just from confusion among consumers, but how about confusions among brokers and advisors? How about confusion among the compliance departments? So the SEC, I think, has gone yet another step towards the direction of institutionalizing this notion of not defining and what a fundamental term means, and going forward. Now, one of the responses is, well, this is a principles-based standard, so you can't define it. And I say respectfully, that's a bunch of BS. And I think that even though it's rarer today, there are precedents where the SEC actually has defined what it meant. And Ron probably knows what I'm going to reference as a site, and that's the matter of Arlene Hughes. But my point, and I know, yes, it's 1948, it's our grandparents' generation, but the point there is really important. I guarantee you that any broker reading that opinion in 1948 understood where Arlene Hughes went wrong and understood what he or she needed to do. There was no ambiguity about it at all. What did the SEC do? They sort of climbed into the shoes of the investor, and they found out the investor didn't know what Arlene Hughes was, didn't know that she had a huge conflict, and based on that decided, no, you have violated the fiduciary standard. And so, sometimes the SEC makes this out to be discovering the cure for the newest cancer, but it's not. It's doing some basic things that used to be considered common sense. And Arlene Hughes is one example of the fact that, guess what? Anybody could, I think virtually anybody could read that opinion and know where Arlene Hughes went wrong and what she should have done to make it right. So it can be done. So that's an example to me about why it is so serious that best interest hasn't been defined, and there's been relatively little reporting on that. The second issue I want to focus on quickly is the issue of conflicts of interest and the definition there. And I mentioned this in the last session to say that over the course of the last 20 to 25 years, the SEC has fundamentally changed the definition of conflicts from the definition given in the Investment Advisors Act, and that was still alive when Arthur Levitt was chairman, as seen in the Tully Commission. What was the purpose of the Tully Commission? How can we get brokers, dealers away from commissions to reduce their conflicts? That's what it was all about. And then as recently as 10 years ago, and that Ron and Ben in August may even remember this, we had a senior staffer from the SEC make a very interesting speech 10 years ago at a compliance conference to say that, guess what? Conflicts are like a virus that is potentially mortal. It's deadly. And so it's not that long ago that we had a view of conflicts, but today that is switched. And today they have redefined it to mean that any firm that has an interest in creating any additional revenue is experiencing a conflict of interest, and that's how it's defined. And so what does that mean? That means that there is no difference between a broker-dealer conflict of interest and the IA conflict of interest in the view of the SEC, which a view is, by the way, which is reflected also by the CFP board. And the CFP board even goes in more detail in terms of a couple of its papers on discussing this, that you fee only advisors, you've got a conflict too, and don't think for a moment that you don't. And they shake their hand, they shake their finger. And what they never say is that, guess what? There's an enormous difference in scope, in scale, in opacity, and in complexity between these conflicts of interest. They never go there, but that's what it is. And our friends in the fee-only world, they've long since given up sort of pointing that out. And so the fee-only folks are put in the same bucket as the Merrill Lynch full-service broker, and you all have conflicts of interest. So don't give me this BS. In fact, we had as Ron will recall, because I know he was on these visits, we had a former commissioner who was briefly the chair, who made fun of fee-only advisors for fixing their halo. They made fun of fee-only advisors, where in fact fee-only advisors are a natural offspring of those that gave us the Investment Advisors Act. But it seems that most people seem to totally forget this. And in today's world, we're all the same. We all have conflicts. And so don't give me anything else. So I'll stop there and open the conversation up to our journalists first on the call. I think I see Mark and Tracy still hanging on, and then the panelists from the prior panel are welcome to chime in. So, Mark.
My question for any of the panelists, over the course of an hour and a half now, there doesn't seem to be any kind of love for the SEC staff bulletins on Reg BI, and also criticism of the enforcement, the one Reg BI enforcement case. Could someone boil down to just a few sentences, one paragraph, of what you want to see from the SEC that would clarify Reg BI to the point that you would say, yes, this is helpful, this will make a difference? What could they do? What would you like to see them put out?
Mark, I just got, like I said, I just came from another panel where it was industry professionals, experts on every side, consumer, we're talking about broker dealers, and everyone wants clarification and the answers to that question. They want to know what Reg BI means and how is it different and how is it going to be enforced. So, you take away the hats of who's wearing what. I think clarity and clear clarity as opposed to more confusion, because every time the SEC puts out a bulletin, or now that they're putting out this enforcement action, the broker dealers are looking at this and they're trying to get clarity about what do they need to do to comply with this new regulation, Reg BI, and they're using the enforcement action as guidance. As an investor advocate, we're looking at it and trying to understand, where does it leave us with respect to the obligations that the brokers have? So there's no magic answer, but to me, the simple answer is clarity. And how does it, and this all comes down to, whether you're an advisor or broker, you should, the whole basis of the securities industry is fairness. And I feel like the more layers that have gotten added on, and maybe it is a complex onion, and there are a lot of layers, but it really needs to be boiled down to fairness, the fairness in the relationship between the broker or the advisor, whoever is offering that investment advice, and how does the SEC get to that point? So I don't have a magic answer for you and what I'm looking for, but I can tell you just that from the room that I just came from to this room and listen to the conversation from the previous panel, that what it seems to be the same answer from everyone, the same theme from everyone. They want clarity. They want to understand what's going to happen with this new regulation.
Thank you, August. Ben, Ron?
So I'll jump in here and say that I don't think this is a problem that the SEC can solve with additional guidance. The difficulty we face now is that the SEC still has to implement and enforce regulation best interest. And given the way it was drafted and the vagaries of it, the flexibility of it, it's very hard for the SEC to impose a very stringent meaning on that after the fact. So the challenge, I think, is that you can't expect the SEC to completely revise the regulation through guidance. That's not, that if they want to make those kinds of significant changes, they'll need to do a new rulemaking process. And at the same time, I can sympathize with the concern from the brokerage community about the lack of clarity in their obligations. And so one of the challenges is that you don't want, as a policy matter, you do not want to go around and ambush firms with enforcement actions when there was nothing that in the text of the rule that would have made clear that what they were doing was a violation. So here, this initial enforcement action, I think, is very much fair game given the nature of the allegations and by focusing on the care obligation there. So it's the SEC. I don't want to say they don't get any love. I respect what they're doing and the effort that they're making, but I do think they're in a very challenging position given the rule they have to enforce.
Thank you, Ben. Ron, do you want to add anything?
Just two quick thoughts. One is I would hate to be a broker-dealer chief compliance officer right now, trying to figure this out, because you really don't know what the standards are that are going to apply to you. And second, kind of dovetailing what Ben said, but going a little bit further, I don't think Reg BI can be fixed. I think it has to be replaced.
Thank you. Mark, any follow-up to your question?
No, not right now.
Okay.
Thanks. Thanks,
Tracy, do you have anything?
Sure, Knut, thank you. August, I'm wondering, and any of the participants, if in the area of arbitration, you're able, to use Reg BI. I see it named in more and more arbitrations. If you think that you will be able to do some defining through that forum, to more clearly define at least, from the stick perspective as versus the carrot perspective, what is allowable.
Absolutely, and I think that we're just getting started with that. If you look at the statistics, Reg BI as a cause of action or claim has just entered, I think, the top 5. There was a poll done in the last room I was at, and I think it was like less than 20% of practitioners had even brought that type of claim yet. So we're still in the early stages, but absolutely. And I think that, I think timing wise, these GWG type cases is going to be a good spot for that, because a lot of these bonds were sold after Reg BI went into effect in the GWG's 4th offering. And we're going to be, I think that the arbitration process is going to be new for us in the sense that we're going to be looking at these other areas, things like reasonably available alternatives, things like the costs and commissions internally available to specific broker dealers, and what was the business model of that broker dealer that sold the product. Was this a broker dealer that sold only proprietary products and alternatives? Was this a broker dealer that was full service? And then each one of those types of situations, you're gonna have to pry differently to kind of peel back the layers and see where the applications are. And one comment that resonated with me earlier today is that in these arbitration matters, this is gonna cause a lot more. It's gonna be a lot more document intensive, because these care obligations, or at least where it's kind of pointing to, and with Reg BI, and have also the obligation, the disclosure obligation, and the compliance obligation. Especially the compliance obligation is going to allow us as practitioners, or at least as investor advocates, to maybe peel back some of those internal layers on due diligence, on training, and about reasonable available alternatives. Again, those things have been harder to get under suitability standards, or at least the reasonably available alternatives. So I do think that there's going to be some ways where we can help define it in our arbitrations going forward, at least. But unfortunately, that's a lot of times that gets stuck in your single arbitration. So we have to explain it to each arbitration panel individually. And I don't know if that fully helps move the needle that much.
Yeah.
Okay.
So to follow up here, to some extent, these questions may be unanswerable through arbitration, because arbitrators, at least in the FINRA forum, they do not explain the rationale for their decisions, and their decisions don't have precedential value like you have in court decisions. So the SEC's enforcement action, if it does generate some judicial decision interpreting regulation best interest, will provide excellent guidance for future disputes, future arbitrators to apply. But the problem we're going to face is that many of these claims, they're almost all going to end up inside an arbitration forum, and then they don't generate the same kind of precedent that you would through the traditional legal system. So you never really get true clarity on exactly what regulation best interest means. In some sense, we're setting ourselves up, for what is a version of the myth of Sisyphus. You're going to be rolling this Reg BI rock up the hill every arbitration, trying to explain what it means. Rhetorically, I think it's superior to the suitability obligation, because you would hear in arbitrations, defense counsel saying things so they don't have to act in somebody's best interest, so they don't have to do that. So maybe it moves the needle in terms of what arbitrators will do when they look at unfair and exploitative situations, but it's very hard to say what it's going to mean, because you don't get clarity ever through arbitration.
Thank you, Ben. Bob, are you still on the line? Okay, I guess not. So one thing that I'm hearing from Bob is on the line.
I am here. I just had to fumble around and find my camera and mic.
Okay. Bob, I wonder if you had any comment on what we've just heard in the last few minutes from our three professors here, or attorneys, regarding the limitations of Reg BI and what that means for the implications for going forward in a positive way, which you sort of ended the last session with that sort of question. I wonder if you had any additional thoughts on that.
I really honestly think Reg BI was created by an SEC regime which was completely captured by the brokerage industry, and it was not intended to be enforced as if it was a fiduciary standard.
Yeah.
I don't think it constrains the brokerage firms at all.
Yeah. So in terms of going forward, I guess, and maybe I'll address this to you and then to the other panelists. Does that mean in the short term, at least, that fiduciary advisors should be looking elsewhere than the regulators on the federal side? And we haven't really touched on the state regulators, how they can come into it, but we know that I think they have a different attitude in many states than we see on the federal side. So I wondered if Bob, you had any thoughts on that, and any of the other panelists as well.
No, I want to tee up the other panelists. I think my opinion is that advisors should be completely ignoring the regulators. Yeah. And doing whatever they feel like doing without, any concern whatsoever about what the regulators are likely to do. And that's, of course, a straw man that I'm hoping that they'll elaborate on and dispute.
Yeah. So I'll jump in here. My advice would be to not expect the SEC to be your savior here, but also to think about states. And so Nevada has the nation's only fiduciary statute. Of course, it's still primarily enforced now through arbitration, so there's not a whole lot of clarity on exactly what it'll mean when customers bring claims. There's no reason that other states can't turn around and pass these kinds of statutes to regulate financial advice in their state.
Yeah.
The SEC doesn't have to be the only entity that is going to raise standards here. States still have authority.
Yep. Ron, any thought on this? August? I guess not. Okay. Then what I guess I was also wondering, I guess I made a pretty strong statement that given what we've seen in the last 6 months with the new SEC, that it has regarding Reg BI, regarding conduct standards, it's basically continued the path of the former SEC. This may be a little bit risky, but I'm curious whether to what extent any of the panelists sort of see it in that way, or whether that's in your view not the case.
So I think the SEC it's got a limited amount of personnel, and it can only do a limited number of things at a time. I think right now the SEC's eye is focused heavily on ESG issues, green funds regulation, and changes to disclosure standards for issuers. All worthy fights, and I don't think the SEC has forgotten about the plight of ordinary investors and retail investors and the problems that these conflicts of interest pose. But I don't think it is the core or single-minded focus that they have right now. So I don't think the current slate of commissioners, I don't think they would have passed the current Reg BI, but I don't think they're ready to replace it just yet, even if I would like to see it happen.
Gotcha. Tracy and Mark, any follow-up questions?
I'm set, thank you.
Okay, Mark?
No, I think I'm set too. Thanks, Knut. Thanks for hosting these two panels. Okay,
then in the few minutes we have left, we've got a number of our members here. Do you have a question for any of our esteemed panelists here? I see Andrew, I see Dan, I see Kent. Any questions for any of our panelists? Bob?
I think the question to ask is, all right, let's say that somebody made you the SEC commissioner, and they'd probably have to hold a gun to your head to get you to do it. But if they did, how would you replace the Reg BI standards, or what would you do to replace Reg BI and create something better?
Thank you, Bob. Okay, Ben, that's an easy one. Ron, that's an easy one.
And so one of the things I think that's worth looking very closely at is what other nations have done. We're not the only nation to have capital markets to distribute financial products. Australia has embraced a very different system where most retail products aren't sold on a commission basis. The United Kingdom has done the same, and I think it's worth looking very closely at that. If it is true, if we conclude that commission incentives distort the quality of advice and they also cause problems in the capital formation process, then maybe we want to move away from that. And the question then is, well, does the SEC have that kind of authority, and can it go there? So I think that's an issue that we have to always be thinking about, whether or not we want to keep running our system the way we do with the incentives we have.
Yeah. Ron or August?
I would generally agree with that. I think, if I was to use Knut's hypothetical, I would attempt as a commissioner to eliminate as many conflicts of interest in the broker-dealer community as I can. And even to the point of levelizing commissions for all products, without the false dichotomy of, hey, this is a more complex product, therefore you ought to get paid 10 times more. To me, that doesn't make much sense. It just leads to a lot of abuse. And if you do that, I think it's just going to push more people away from the brokerage model over to the investment advisor, the fiduciary model. Once you get rid of all these back channel payments that seem to crop up, and you go strictly commission. When you think about it, any commission can be turned into a flat fee by an investment advisor. Say, okay, I'm going to build a portfolio for you, or make recommendations to you. I'm going to charge you this flat fee, and then go out and search for the best products. So the other avenue, which Ben was suggesting, was basically applying a fiduciary standard. I think if best interest doesn't work, and I'm not convinced that I agree with August, I think, and Ben, that there will be some marginal improvement in the duty of care, maybe some marginal improvement in the due diligence process that we see being observed. I think we've already seen a little bit of that. But I don't think in the end of Reg best interest as it is right now, because it's so vague. I fear that with changing administrations, we're going to have a different standard, essentially. Right now, it's emphasized that best interest means best interest. What's it going to mean under the next administration? So I kind of wonder if when Reg BI fails, and I think it will fail eventually, whether it's going to be replaced by the fiduciary standard for everybody, which I'm not necessarily in favor of. I think you still have a place for sales of financial products in our society. We're definitely a more capitalistic social structure than you see in some other countries.
Yeah.
But we may be headed that route when Reg BI, as I believe it does, ultimately fails.
Right. Ron, you said something that causes me to have a quick follow-up for any of the three of you. Early in the Reg BI process, as I imagine that you will recall, the Republican, one of the Republican commissioners actually had an interesting idea, I thought, and this came out in the April proposal. I think she put in writing that, what if we required brokers to actually disclose the price, the cost of what they're recommending, as opposed to just disclosing basically what is a price chart, a price schedule. And of course, that was Commissioner Persh, and she actually put this in writing, and but it didn't last very long because it was quickly dismissed. But I have believed that, notwithstanding all the evidence that investors, the relationship between investors and disclosures, I think there's a carve out there that we have got some reason to believe when it comes to cost and price, they're more attentive. And I actually believe that if it was the case that brokers could be as transparent and clear as independent RIAs can be, there would be a huge dynamic that would shift in a positive way. Now, and so, I mean, and I suggest to our fee-only friends who don't like to focus on price because they think the guy across the street is going to not tell the truth and then they're going to be at a disadvantage. But I say, you have an advantage the guy across the street can never get, because you can tell Mr. and Mrs. Smith what they paid last year in total cost that is pretty darn close to the total cost. The guy across the street doesn't have a clue because his own firm won't tell him what the total revenue situation is. So anyway, all that to say, I'm curious whether that would be something that you think could be hopeful in terms of being beneficial, if it were the case that the BDs who can tell broker Smith to the penny what he's brought in last quarter would be able to would be required to share that with their customers.
No, I would fully support that kind of disclosure system where you have to disclose the commissions and the profits to the brokerage firm or the fees flowing to the brokerage firm at the point of the recommendation.
Yeah.
And you know, I am somewhat generally skeptical about a disclosure solution in the space, but that's something that's simple enough that people could understand it, and it allows them to evaluate you know, the scope. So you know, we know that this works because when they changed the disclosure rules for non-traded real estate investment trusts about how they were disclosed on people's statements, they stopped selling them simply because you could sell somebody a product for $10 a share, and they would then list the shares at $10 a share, where in reality these were investors who would lose about 13.5% as soon as they made the investment. And they were just able to continue selling it because investors did not understand.
Bingo. Yeah.
Yeah, I would add, I agree. Going back to the last question, if I was the SEC commissioner, obviously we live in a disclosure type of environment, and I do agree with Ben with respect to skeptical of adding more disclosures would actually be helpful. But I take it back to being an attorney that has talked to thousands of investors that have no clue that that the person sitting across the table from them is a sales broker, is a salesman. I've never had one person tell me that they actually knew that their person across them was something more. It was not a trusted advisor as opposed to a sales broker. So sometimes the simplest disclosures might be the right answer. At the point of sale, disclose the amount that they're getting paid for the product that they're selling, and disclose that you're a sales broker. Maybe sometimes the simplest solutions could get you to a better understanding, because the average mom and pop person that's sitting across the table from their quote unquote trusted advisor has no clue what regulatory system we're in or what any legal work that's being in front of them means. And it only adds more confusion.
Yep.
I would add, I think disclosures can be a positive thing, but I think we have to recognize their limits. And I go back to the Harvard MIT study that was done by Professor Choi and several others, in which they basically gave to these fairly educated MBA students, hey, here's 2 S&P 500 index funds. This one's more expensive, this one's less expensive. And most of them chose the more expensive fund. Investors tend to think, hey, this is more expensive, it must be better. And the reason we have a fiduciary standard is because disclosures don't work very well in a very complex situation like this. It's different from buying a car or buying something with a warning label on the side. Fiduciary duties exist because people need trusted advice to navigate these markets. And I just worry that although I would be in favor of pointed recommendation disclosures, I don't think that they're going to solve the problem.
Gotcha. All right. Well, thank you, gentlemen. Thank you, Ron. Thank you, August. Thank you, Ben, for serving and for sharing your thoughts. And thank you to the attendees, advisors, and journalists who also joined. And I guess I'm assuming that there's no last-minute thought from Mark or Tracy, but I don't. Okay. But so that thank you one and all, and we should have a tape of this up in 2 or 3 hours.